And to start, I'll invite Louis and then Silva to give an overview of the evolving data privacy landscape in East Africa. What are you seeing from the region? Louis, I know you have been working on data protection even before the countries in the region got respective data protection laws, but you have done some work on right to privacy, digital rights. How would you, in summary, what do you see when you look at the region in terms of data protection?
Okay. Thank you, Francis. Thank you, colleague. Warm greetings from Kigali, Rwanda. My presentation will be brief. And as you know, in East Africa, Rwanda and Kenya has been one of the major actors in terms of technology. Our country have built a quite very consistent and very impressive kind of infrastructure in terms of access to technology, but also has put some of the best conducive policies in terms of making Rwanda one of the hub across East Africa. But also we can't hide the fact that Rwanda also is a serial offender in terms of using digital surveillance and buying very, very expensive and state-of-art spywares. And then you may be aware of the recent saga about Pegasus and the abduction of Mr. Paul Rusesabagina from Dubai, and all the controversial stuff around that. But briefly, what is the stake and what is the situation here in Rwanda as we speak now? I think Rwanda has, you need to make a difference between the distinction between in principle and practice. In principle, Rwanda has signed almost all the regional instruments in terms of protecting human rights and promoting access to the rule of law. I mean, as we speak, as regard to data privacy, Rwanda has signed the Malabo Convention and it has ratified. And more recently, I think in 2021, we enacted a data privacy and a data protection and privacy law. But what was the rationale behind the law was not actually, I mean, the official narrative from the state was let's have a legal instrument to give a much more conducive transfer of data, to provide a platform for investment, especially for tech, for startup and tech and fintech startup to operate in Rwanda, and having a kind of legislation to provide for a conducive share transfer, overseas transfer of data. But the true rationale or the agenda behind the government at that time was to put in place a legislation, because at that point when Rwanda was pushing for a data legislation, personal data legislation, the government was undergoing negotiation with the UK in terms of relocating migrants. And behind closed doors, the UK government asked the government of Rwanda to provide for a harmonized legislation, so both government can share personal data. And you do understand that you can send migrants, you can relocate asylum seekers without sending back to the destination country their data, their personal data, their identification, and all those kind of information. So basically, that was the rationale when Rwanda passed the data protection law, and the law was passed in 2021 and had a transitional period of 2 years. Then the law became fully enforced and all private and public entities were called to comply with the law. So how far we are now, we have a law, and the law is, as many African countries, is just another copy and paste of the GDPR, and basically it reflects all the components of the GDPR. Unfortunately, the data protection law, as many laws, doesn't really reflect Rwanda's socio-economic context, especially in terms of informed consent, because as you know, our people are not aware. I mean, they are not aware about what means informed consent and what's the stakes behind that. So we have a law, but now we have also a data protection under the Rwandan law is called supervisory authority, which is basically the same in Kenya, which is a data protection commission office, which is the regulatory authority in charge of enforcing the law and to make sure that all entities operating in Rwanda comply with the law of the land. But now what we are facing as issues and basically given what's on the topic I covering here, as I give you a bit of context, we had, the law was, especially, the law was mainly designed for, the Rwandan government was in the middle of negotiation with a controversial, with the UK, the previous UK, the Labour, the Conservative-led UK government. At that time it was Rishi Sunak, but even before it was Boris Johnson. And for us in Rwanda, the law has not yet been tested. I mean, being tested in terms of challenging some of the dispositions of the law in domestic courts. But we have
having network issues, but thanks so much for that. We'll proceed to the next question. And Mr. Mtua, I want you to share insights into the formation and structure of EADGC. And of course, I can remember I was there as well. There were certain motivations that we had. Also, Mariam, if you have a few insights, you can also share. Like when we were coming up with the Data Protection Practitioner Society, what are we trying to achieve at the time? And then now to lead us to the next question.
Hi everyone. My name is Mutua Muchuku. I want us to have an interactive session. So the formation of societies is basically me and you sitting down and saying, look, we are professionals and we have a common agenda. Think about it in these lines. Folks in Nairobi who drive Mercedes-Benz, they have an association, right? Same thing with guys who do Demios, Land Rovers, same association. I'm so sure if any of you here was going to Kigali to go and see John Legend, you formed a WhatsApp group with the same motivation. This is our goal. So the same thing happens to associations that deal with data protection and privacy in terms of either as a practice or even as an authority. So it's the same thing that, it's the same idea that was here, guys whose intention is we are looking at the advancement of the practice of data protection, either in Kenya, regionally in Africa, and globally. So those were the ideas. And a few guys, I know you are some of, you are among the first people to sit down with Kina Oles, with Kina Chemu. I know all these are familiar names. I'm not mentioning people you guys don't know. So they sat down, they came up with, look, we're looking at advancing the practice of data protection in Kenya. And here is an an organization, and they formed the Data Protection and Governance Society of Kenya, purely for the advancement of the practice of privacy in Kenya. Now, Louis, sorry, I took over. You got disconnected a bit, so sorry. Yeah, you'll have to listen to me briefly. So that is the genesis of Data Protection and Governance Society of Kenya. And it takes 3 layers in terms of the structure, where we have the office bearers. I think I've seen Kisaka here, who's the organizing secretary. Laibuta is the chair. Chemu, what is Chemu's other name? Rosemary. Sorry, I call her Chemu. Chemu is the vice chair. James Mbogo happens to be the treasurer. So those are the office bearers. After the office bearers, we have a council. A council has people who are nominated from the different areas. And the reason why they're nominated from different areas is so that you can capture the entire matrix of protection. In that council, we have someone who's representing the academia to take care of the interest of folks in the academia world. We have guys who in active private practice like me. We have a representative there. We have people who do data privacy practice as in-house counsels. So the guys who can only practice in-house. So they are represented there. We have students. We have a cohort of students, a student representative. They are also there. And then after that, of course, I've not exhausted the list because of time. After that, we have trustees. So trustees come in the event that our vision is to grow and become such a big entity and own property and own cars and do the marvelous things that we say in our utopia world. So when you own property, when there are things to be done, it is left with the benefit of the trustees. So that is the structure of DPGSK. That is why it was created. We have objectives. One of the things that we've been able to do is we've created training programs on a monthly basis. I think I can see Naisenya smiling there. She's one of the people who's done CPDs, which is continuous professional development episodes, where we come together and we brainstorm and we continue building the society. We do mentorship program especially for young folk in university, guys who are 1 year into practice, 2 years into practice, or even the oldies. They've been there, but there's a revolving door where we have new technology that is coming in and saying, look, my guy, this is new technology. I do not bloody understand it. So I need a young guy here to explain it to me. So we do both mentorship in its natural way and reverse mentorship, where now the young guys are mentoring us. And we also do what we call public policy. For example, before June 25th, for those who are Kenyan know what happened in June 25th last year, where we had mandamanos. One of the things that we had was the rejection of the finance bill. And one of the biggest talking points was a few things that Kenya Revenue Authority wanted to introduce in the Finance Act, saying, look, we need to snoop into your funds. We need to be able to see how much are you being paid. Why are you driving a big car and we can't see that income in any of our... So they were trying to introduce some of those clauses. And I remember the DPGSK put in a memorandum. It was presented in Parliament. But of course, you know how parliamentarians took it. We have also been involved in a number of public interest litigations, where we are challenging some of the things that the Big Brother is always doing. We are involved in the matter about challenging the existence of the ODPC. We are also involved in, I think there's another Okiom Chata matter that I can't remember. Personally, I'm involved in 2 matters. One, challenging the IMEI registration number when funds are coming to Kenya and the registration of it. We're also challenging the SHIP and SHA. If you're a Kenyan, you know what that means. And if you've looked at, if you're a guy who has a payslip, you've looked at that payslip and you know, no, this can't happen like this. So those are some of the things that we've been doing. And also we have fun. We meet at the end of the year. eat together, dine together, get to network, catch a pint here and there, and enjoy ourselves. Yeah.
Thank you for that. Mariam, as you explain further, also, I want you to highlight now the work that you feel that practitioner societies can do in enhancing understanding of data protection laws and supporting compliance among these organizations.
Thank you very much. I think I'm going to add a bit to what you just said. So in speaking for myself, because I started working actually maybe, graduated maybe 6 years ago. Sorry, I'm saying, speaking for myself, like one of the benefits I saw for, especially from the society, the funny thing is I was also one of the founding members, and I was fairly new in a profession that was just coming up. And like let's say I was working in the human rights space as a digital rights officer. And by that time, that role, when you explain to somebody what it is you do, like barely anyone could actually understand what it was you do. And the one thing that I noticed benefited me and a lot of the people that I know who have currently made their way into the space is this particular society. The one thing that really stood out to me was the fact that everyone agreed. Like there was no siloing, there's no other pop-ups of other societies. Almost everybody came to the same table. And this was people in academia, people in private sector, people who worked at the grassroots level, people who have mostly primarily worked as researchers, and also people who had even worked on the Constitution of Kenya when the clause on privacy was being put in, way before data protection, the word itself, became a buzzword. So that really stood out to me. So in terms of the question you've asked on the enhancing of the understanding of data protection laws, one of the things like EADGC, for example, does is towards the end of last year, there was a report that was put together, mostly highlighting all the different cases that had come up around the area of data protection. This means that, and it's in a very simplified way, in which whatever sector you work within, you have a place where you can go for knowledge management and, like, knowledge sharing and knowledge building. So one of the things that societies have been really, really key in highlighting is, one, the progress of, like, let's say the enactment of the Data Protection Act, for example, in Kenya, which actually came to the 5th year birthday, I think, was sometime in December, and the society was front and center in terms of really advocating for the strengthening of, like, let's say, the Office of the Data Protection Commissioner. Because one of the things I've had consistently being said is that this is a kind of a, I don't know how to put this in a nice way. I'm looking for the word. It's just there, guidance notes, but no, it's all bark, no bite, basically. So the site, for example, plays a very pivotal role in ensuring that, even pushing for some policy reform that would go into better funding to ensure that this particular office that is meant to be, like, overseeing data protection across Kenya is not seen simply as a floral office. Yeah. So the other thing is, even within the society, it's not just lawyers. I know we like, oh, there's a lawyer here, there's a lawyer there. Nah, there's a lot of people who are also technical experts, meaning that in the things that, let's say I would say I'm both a policy and legal practitioner, but then I don't understand everything when it comes to the technical aspects of, technology. So there's language I would not have, and there's also an understanding of technology that a practitioner who did tech or has a background in IT would understand. So the society has brought together different people with different expertise in a way that we're not just saying things when you're pushing for policy or legal reform that we're not understanding. There's always somebody to complement somebody else's areas of expertise. So this means that even when it comes to pushing for policy and regulatory reform, there it's always like in a practical way, because there's things I could go and I could say, and it's, oh, I'm living in a utopia world, yeah? But then somebody who understands what the technical aspects of what I'm trying to say when it comes to data protection, when it comes to privacy, they'd be better informed in making sure that I'm not just pushing for policy reforms that are not practically implementable. The other thing that I believe societies play a really key role in is simplifying language. Because today I saw something very funny on Twitter. There's a conference happening somewhere else, and somebody said, oh my gosh, why are all these people talking like, academia and so it's like it's a mixture, and I'm hearing all these words, like multi-stakeholder, AGI, and it's like, okay, how are you simplifying this language for the general population to understand? So societies play a very key role in ensuring that the language is not purely academic, and it's never purely like, oh, regulation or policy. In order for there to be like a, let's say, national support, you see the way when the Mandamano were happening, there was so many people taking part in the breakdown of the finance bill, up to the like there was like people offering to do in Kikuyu, people offering to do in Meru, people offering to do in Akamba. The truth is the ideal situation would be that societies are able, the data governance societies are able to also break down data protection, digital rights conversations into something that is completely soluble for the general public. Otherwise, we're speaking within echo chambers. So even as DPSGK, sorry, oh my gosh, that word is killing all of us, really. One of the things we are particularly keen on is making sure that the language is not purely technical, and it's not purely legal, and it's not purely policy. We have to be able to speak to everyone, and if we are really meant to like obtain our end goal. So I don't want to take up too much of the time, but thank you.
Thank you very much for that. I can see Mr. Silva has joined, and welcome. I would like you to share a brief snippet about data protection in Uganda, and then also talk about how do you think, what has been the impact of the Act ever since its enactment, and is there a society? Are there plans to be a society? Is there an informal one? Yeah. A society of privacy practitioners. Yeah.
All right. Thank you. I hope you can hear me clearly.
Yes, we can.
Yeah, so thank you for having me. So we have an act, yes, I think it's a 2019 Data Protection and Privacy Act, augmented by the regulations of 2020. So obviously in terms of the institutional framework, like many countries, we have the National Data Protection Office, which has had a few inquiries into operations. Largely it's, with the Safe Border, which is the border ride-hailing company here, at the bit of an inquiry fleets that are handling procedures. But putting that aside, the Act was enacted during the process of rationalization of government programs. I think Kenya is embarking on that process. So what that meant is at the time there is a freeze on creation of new regulatory or administrative agencies in Uganda. So much as we have the National Data Protection Office, it actually sits or it's housed at the National Information Technology Authority, NITAU, which is a government agency. So of course in terms of the independence, some questions have been asked, given that government is one of the largest data collectors, processors, and all the attendant issues there. From a cross-border perspective, of course, Uganda is largely about national economy, and so most of the East African parent groups will be in Nairobi. So the Ugandan subsidiaries, depending on the strategy that they are adopting, we've seen a lot of cross-border data movements in the sense that this is necessitated by several factors. The first is that some companies are pursuing a data consolidation strategy, and this will mostly be the banks and financial institutions, that they will, because of obvious risks and reasons, rather than having all their data scattered across all East African countries, group is moving to exert a much more control in terms of warehousing that data in Nairobi. But two is also shared facilities, instead of having a core banking system or an enterprise resource planning and management system in each and every country, with each and every subsidiary having its own, it's becoming imperative for group to have control over those vital IT assets. And maybe the subsidiaries can have stuff like mirror data centers or stuff like that to be able to access all that type of information. And maybe the third driver of such trends is different countries at different levels of maturity. I think Kenya has moved faster, in terms of even determination of data protection compliance. I think Kenya has done a tremendous job. In Uganda, you will struggle to find quite a number of decisions. However, many of the court decisions have been on image rights. I think that has received much traction because, that's a piece of the personal data that's in persona and held as in persona right. And the infringement is near obvious. If you are at a party and they take a private photo of you and then maybe post it on social media, voila, you have a cause of action there. And then maybe the last strand I will talk about is the typical sort of work we do. It's the usual, There is a lot of policies involvement. A lot of work has moved from draft for me a data protection policy, but now we are doing lots of things around data transfer agreements, especially between parents and subsidiaries. We are doing a lot of managed services agreements, outsourcing agreements where the data is being held by, external third parties. Of course, with the COVID push, we have a lot of work from home policies and how those relate to data protection. Bring your own device policies where the employees are bringing their own devices. Password policies, CCTV policies. This is becoming big, together with biometric policies, because there is a lot of biometric data collection in the corporate workspaces, especially with access controls and all that kind of stuff. Private CCTV is big. All the concerns sought at that stage. But we've also seen, because the public CCTVs are not that many, in terms of the policing perspective, is where a crime will happen. Then you have to guide businesses on how they can release that footage to police and other law enforcement agencies. So we had to draft those sort of CCTV footage sharing agreements. On the whole, I would say from an East African perspective, if data protection were a baby, I think some countries are at chronic stage, others are starting to take their first walk, staggering while walking, maybe while others are walking in terms of confidence and about to get from an enforcement perspective. Let me leave it at that, and maybe later we can get into the granular details of how this impacts human rights, and in case, I'd be keen to hear more about the perspective around all these remissions and, data exchange in the enforcement agencies that seem to be making a resurgence across the region. Thank you so much. I'm keen to learn more about the perspective of others.
Thank you so much for that, Silva. Thank you for giving a summary of the progress since the enactment. Aware of the safe border decision. It was, I think, one of the first ones in the region. But now I want to hear the voice of an outsider who is also an insider. And Katua, this is for you. You have done a lot of work over the years in supporting legislative efforts in different sectors. And the question that I have is, in your view, how do you think these societies can advocate for human rights in the context of data protection laws? And still in the same breath, like, what opportunities are there to influence policies and promote best practices, especially now when, as a society, we get, let's say, draft regulations from the ODPC or from the ministry, and we want to engage because we are the practitioners. I work in-house. He's a lawyer in private practice. She consults. There are various things that we see when we are working for our various clients, and we want it to be considered whenever legislations and policies are being enacted. So, in your view and based on your experience in legislation, how do you think we can advocate for that, and which opportunities are there for us?
That's a heavy question. So first, I'm just wondering how I'm not a member of this society. I'm hearing very nice things. You're saying lawyers are there. Mariam has never told me. I look for you. You may attend. So my name is Sylvia, and I work from Zalendo, which is a parliamentary monitoring organization. Ways in which I think the society can help, especially where there are human rights violations. So I think when we talk about human rights violations in data protection, the first right we all think of is the right to. I can't hear you. The right to? Exactly. That's always the first right we think of when we think about a human rights violation and data protection. But there's so many other rights that can be violated in terms of data protection, data breaches that may occur, and even any sort of contradictions against the Data Protection Act. We have, and we've seen them post June 25th, and in the context of the mandamano that we've had, freedom of assembly, freedom of association, freedom of speech, right to privacy itself, and even freedom of movement. I mean, if you're being held. So how can this right be violated in the first place? I think that's the first thing for us to consider. When we talk about human rights violations in data protection, I think the crucial thing that we always try to consider is the balance. That balance. What is the balance between this right, whether it's the right to privacy, the freedom of association, freedom of movement, whatever it is, and the legal limitations that are under Article 24 of the Constitution, as well as, I'd say, the realistic nature of what's going on. How do we balance all this out? And that's something that always occurs, but at the same time, these violations happen. Society, how can we help? And I think from what I've heard, I think most of it is already taking place. Advocacy, awareness, training, working with human rights defenders, working with civil society organizations that deal with human rights, just trying to train them and assist them, help them identify. Perhaps it's possible that sometimes human rights defenders and even people like, okay, not just human rights defenders, but even ordinary citizens don't know that their rights are being violated. So it's important for the society to just come up and provide this sort of awareness and knowledge training. And then if you also think about it, redress. You've said you have a lot of lawyers. Some are in private practice, but there is pro bono work that I'm sure we can be able to do. And it's good to hear that the society is doing some public interest litigation. At the same time, I think it's important perhaps to have sort of like legal open days, or just pro bono, where the society takes up particular cases just to be able to help people and show them that there are different forms of redress. It doesn't have to just be money, as has been stated, especially for image rights. I think there are also administrative sanctions by the ODPC that can take place, and lawyers can be very well placed to assist with that. Speaking out. I think it's very important for the society to speak out. If we talk about what happened last year in terms of the protests that we had, many people from the reports that we were seeing online, and even those who reported to HRDs, to human rights defenders, you'd see that many people were saying that just before they were arrested, what was happening? Their network was not working. They were not able to make a phone call. Their M-Pesa was not working. There was something that was happening. What does that mean? And specifically for organizations, when I talk about human rights, I think another big area of focus that comes into play is telecommunication providers. So whether they're private or public, that's a whole other, but those organizations, the telecom providers, they play a big role towards these violations because then they themselves provide access to authorities for surveillance, for locating, for tracking, for profiling, for discriminating, and this happens in so many ways, not just in the context of what was happening last year when they were trying to crack down on this Gen Z protest, but even if you think about how the government enforces counterterrorism measures. So you'll see that there are various amendments to the Prevention of Terrorism Act, POTA, and I think there was some also of the Security Laws Amendment for 2014, and I think also the NIS Amendment Act. There are so many ways in which the government has leeway, I'd say, to check in, quote unquote, on our communications and what we do through the network providers. And so it's just to be able to see then whether the society can speak out, statements, press conferences, as well as PIL, which we're already doing, just to be able to assist these people. And then lastly, which has also been stated, is just engaging in policy formulation, which then brings me, this I think goes two ways, Francis. Then it means it's a way that the society can do, and it's an opportunity for engagement towards policy influence. Because then it's just not policy, but also legislative engagement. And I think you do that quite well, if I'm not wrong, engagement with the ODPC, engaging in the public participation process, so public consultations, whether this is at the ministry level or in parliament with the committees. Mzalendo provides very detailed information regarding what's happening in parliament, and I'm sure we could be able to just assist the society on that and getting specific information. And so just to be able to give your views. At the same time, you can also, I'd say, initiate the conversation, because you don't have to wait for policy to be brought to you to do the conversating, to do the conversations, but rather you can even initiate a petition to Parliament. Then Parliament will understand that there's something going on, this needs to happen, and then it can take that up. And we're also able to convene roundtables. So that's something else that the society can do. Convening roundtables as an opportunity for policy influence. So forums, roundtables with parliamentary committees, with the ODPC, which I think you already do quite well, just to be able to share insights, share reports, share publications, data on what's happening, just to be able to share that. Something else, as I've mentioned, is research. Very important. I think it's necessary for the society to keep churning out data on what's happening and how best, I'd say, current events, so that we're able to be well informed, not just as citizens, but even the government, such that even when they're making policy, that's happening. I think a good way to just explain this as I finish up, although it might not be directly related, although to some extent it is, because we have to also think about the ethical considerations of many of these things. I know we've talked about how AI is a buzzword, and I have to now bring it in. So recently I was in a meeting where we convened AI moderators, I'd say people who work for Facebook, TikTok, and we brought in members of Senate's ICT committee, so the secretariat, just to listen to these stories. And from how Parliament was reacting, it was like, and I'm sure you know the challenges that these moderators face and the problems that they face in terms of the labor and everything that's going on. And it was like, this can't be happening in Kenya. It was like, we've never heard of this. This is something new. So you can imagine if at that level, such things are not within their knowledge area, they don't know what's going on, then I think it's important for the society to take these things up, bring them to their knowledge, to make them understand that this is going on, and to also push for reform. So at the same time, while we're saying this is the problem, we're also bringing recommendations of the society. And I hope you've noticed I've said we, because I'm now a member of the society. Thank you.
Welcome to the PGSK, and I'd like to talk to our two brothers from Uganda and Rwanda. First of all, I want to reveal that we have DPGSK members who are also not Kenyan. We have some members of the Uganda Law Society who are DPGSK members. So we are open, and we also welcome you, Silva and Louis. But now, Silva and Louis, I've known you two due to your cross-border practice and the work that you've done across the region. And I would like you to share with us a few challenges that you see in achieving compliance in the region? And do you think there's anything that these societies can do? So we'll start with you, Luis, and then Silva.
Francis, can you speak a bit louder on the microphone? We can't hear you.
I am saying, thank you for that. I'm saying, based on your experience of your legal experience in East Africa, what do you think data protection societies can do in ensuring compliance in East Africa, cross-border compliance? Because now we acknowledge that we are members of the East Africa community, and we have companies that operate in these countries, including Tanzania, South Sudan, Somalia, and we all acknowledge that all people have a right to privacy, and by extension, data protection rights. So, which challenges do you see, and how do you think we can help in mitigating those challenges?
Sorry, I can't hear you. Is there someone who can at least write the question so I can understand? Because catching is going.
Okay.
I think my part, I don't know if I can attempt.
You can start, yes.
Yeah, so I think many of the things have been said, but I see some missing strands. Because you'll find, I think, like in Uganda, the largest approach is entities forming associations. So you'll find the ICT Association of Uganda, which probably will have sister collaboration with the ICT's maybe association in Kenya. You'll find the FinTech Association here. You'll find the Uganda Bankers Association, which has some MOU with the Kenya Bankers Association. You'll find the ISP Association, so those types of things. So for me, I think engaging around those models can be good in the sense that if we start up and maybe wrote an East Africa sort of business compliance toolkit for data protection, how would this look like? Because in this sense, data protection is one of the few areas where almost everything is streamlined. As a Kenyan lawyer or as a Ugandan lawyer, the Rwandan lawyer, you may talk to a German lawyer or an English lawyer and the taxonomy is the same. A data subject in Uganda is not separate or different from a data subject in UK or, a data collector, same thing. If you talk of, policies and all this is one of the most sort of streamlined industries at the moment, where it makes it a very right ground for a regional sort of collaboration if you want to foster self-compliance. I know that regulators have also signed some form of mutual cooperation agreements. I know like the Ugandan regulator was in Nairobi probably last month or in December, attending all these kinds of things. But I know some of these guys are acting under very severe sort of budget constraints that makes it very difficult for them to execute their mandate. So to the greatest extent that we can, if we are able to unfold certain initiatives, for instance, I don't think, our society should be limited in, say, funding maybe an inquiry into the data economy or into the IS economy, but if it's an independent report on things that the regulators have not done, the people doing strategic litigation and all these other sorts of initiatives, public policy advocacy, will find such kind of tools relevant for their work, and then you're able to use it up like that. And then, of course, there are activities that are taking shape. I think Kenya also is leading the conversation around things like intermediary reliability. So if you're to see, the accountability around big tech and big corporation and resolving the jurisdictional aspects that entities can be placed before a Kenyan court, that will have a lot of ripple effects even in terms of other domestic jurisdictions. And of course, it will also make the regional work easier in terms of even the strategic litigation, say if it were to evolve and move from local courts to a regional court like the East African courts, you're able to have a big benchmark around that initiative. And maybe the last strand I'll add to that is, I think even in terms of the training, there is opportunity to streamline the training content and curriculum, whether for practitioners, whether for early beginners, whether for young lawyers, whether for IT experts, whether, so that you're able to have a critical mass of people who can speak to the interventions that we want to do. If these economies are consuming similar goods and services, then we can even go ahead and do the risk mapping of where these sort of highest exposures are. For things like financial institutions, telcos, aviation and travel, the data to say between Entebbe and Jomo Kenyatta Airport on a daily with those flights is just, mind-boggling to look at. But who's come up maybe with an East African sort of travel, leisure and hospitality, the hotels and all these conferences we are hosting across the region. So in terms of, the interventions, I think those would be critical. I'm sorry I'm quite very high level in terms of thinking, but I know on ground things might be different. To look into these types of, especially SME compliance and all these other, Lucas, Tuakalis, etc. Thank you.
Silver, you have amused all of us over here by claiming that is high level, and the person who once said that lawyers can lie was not lying. But thank you so much for that. Louis?
Okay, thank you, Francis. I think for me, I would like to just to be brief, because all the challenges I think my colleague and the different panelists have mentioned it. But I think just based on the specific context of Rwanda, I think we need to stop walking in silence. We need to build bridge of collaboration, and I think what is good, Kenya is showing us the way we have some of the best rulings and the best legal precedents with Huduma Namba and many high courts of Kenya cases, which is quite very, very, very interesting. And I think we share almost the same context, the socio-economic context. So I think that what we need to emphasize is let's learn from each other, especially, because Kenya is one of the most advanced in terms of implementing data protection, but also the system has been tested, and we see there is a kind of very positive progress on the ground. We can learn from that and building the best practices. But also I think the last, but not least, we need also to look on how we can build a kind of a regional harmonized system. Because as we say now, South Sudan, Burundi, DRC have not yet enacted a data protection law. So there is a void. At the regional level, we need to look on how we can have a kind of harmonized legal or regional instrument which can give us some kind of direction and best practice to implement for our practice and for our mutual collaboration. Thank you.
Thank you very much for that, Louis. I think that's something that we're realizing. As Silva said earlier, data protection is a unique law where it's the same everywhere, but it's different. The data subject rights are the same in all countries. There's a right to objection, right to restriction, right, to erasure for wrongful information. So those won't change. Those won't change. And as we come to a close, I would like one of the founding members of DPGSK, Mr. Mutua, to highlight what do you think, since the formation of the society, what have been the wins?
Okay, thank you. So I'll just start with maybe some of the wins that we've had at an international level, then I come to the regional level, then we can talk about the PPSK. So I'm so sure many of us, when we wake up on a Monday morning, when you're having a terrible Monday, experiencing your Monday blues, and you open LinkedIn, you check in and you see, I am proud to announce that I'm now a certified information privacy manager. And the name has, for example, if it's Mutuku, now I have an extra title, CIPM or CIPP, right? We've all seen that. Naisanya have seen yours. And I'm so sure so many of you have that. So one of the most acclaimed international organization is IAPP, that is International Association of Privacy Practitioners. And one of the things they've done, one of the interventions that they have undertaken is they've said, look, we need to self-regulate ourselves. How do we do that? Let's ensure there's a standard measure when it comes to education and training. So let's roll out CIPM, CIPP. And now it's become the gold standard everywhere. Everyone who wants to be a certified in data protection has to do a CIPP or a CIPM. And again, that shows you, and this I'm deviating, shows you the powerful effect of the Brussels effect, because you look at institutions in Kenya are even copying what is happening with IAPP. We have so many schools around here. Of course, I'm not going to mention them, but they tailor their curriculum around that. Now, we have the European Union Privacy Board. For them, it's more of the authorities around Europe who practice the area of GDPR. They said, look, let us come with sit down with, let's come up with a board. And you're going to be looking at the decisions. How do we apply the practice of data protection in Europe across in a way that it gives certainty? Because, and I know this is one of the talking points in Kenya, where decisions that are coming from the higher courts that are binding the lower courts are not uniform. And it's one of the foundation of the political conversations around chasing away certain judges. So the board said, look, if a decision is going to be made in Belgium that is going to have a ripple effect around Europe, we need to have the same standards applied in France, the same standards applied in Ireland, the same standards applied in different countries in Europe. So those are some of the interventions that have happened at the international level. And of course, we know that now it's called the NAPD, the one about data protection authorities in Africa, saying we need to have a standing voice from whether it's the protection authority in Kigali, in Kampala, in Joburg, in Egypt, and in Nairobi. We need to have a voice on how we're going to articulate these things. Now, locally, DPGSK, one of the things that I find joy in is today when I see Kenya Revenue Authority, Communication Authority of Kenya cannot impound a mobile phone at the entry ports, whether in whatever airport, because of an injunction that we got at the High Court. That is one of the things that I love. Again, one of the things I also love is that we've had stakeholder engagement with the Office of the Data Protection Commissioner, where if they're launching something, if there's a code of conduct that is coming in, they say, look, we have a good working relationship. Why don't we sit down? We want to hear your views. And we've gone to an extent in saying, look, we're going to give you one of our own to sit in places where we cannot all fit and hear the conversation that you're having there. And we said, look, we have a guy called Walubengo. So in football terms, we call it, we loan him. So we loaned him to the Office of the Data Protection Commissioner. He sits there. In basketball terms, I think we call trading. Yeah. So those are some of the things that I find joy. Again, when I wake up today and I look at my portal, I see a certificate from EADGC saying, Mutua, this is your certificate number 23. And you can use that certificate because I remember we had a challenge, myself and you were trying to register a consultancy with, for AI and data protection. And one of the strangest thing I ever got from a business registration service was, please, we need a certification from Office of the Data Protection Commissioner. And I remember I laughed and I asked, do you guys really understand what really goes on? ODPC does not give any certification. So we put in our certifications from different relevant entities, IAPP, other local ones, and they said, no, we need a certificate from Office of the Data Protection Commissioner. And it was a lot of back and forth between myself, and of course on the other side, many times you're always talking to a clerk, telling you, we need this. But you see, the instructions are limited to that. So me seeing DPGSK coming up and saying, look, we have a certificate for every paid up member of the society. That is an advancement. When I see students doing moot courts around the area of data privacy and engaging some of the members to give guidance, for me, that is an intervention that has won. When I look across the border, when Tanzania Association of Privacy Practitioner, when we have conversations around how they can improve the privacy practice, because I understand now it's when they're setting up, they're trying to do the regulations, and of course, you know, Tanzania is unique in its own ways. So when they tell us we've hit a dead end here, how do we go to the next level? And we sit down and have conversations, we brainstorm, we send some of the experts there, they send some of their people here to come and benchmark. Honestly speaking, that is a hallmark. And I hope this can be extended to the judiciary, because I think there are conversations that don't need just to happen around the privacy sector, because I think it's too niche. I think it could be extended. So those are my small remarks around that.
Anything to add? Okay. I think we're coming to the end, and we'll have each panelist to give us a parting shot, starting with Silva, then Luis.
Well, I think for me, conversations like this are important. I think we should have them more frequently. Because, you know, there is convergence happening at the level of the ecosystem, in the sense that, you know, tech convergence is happening, companies are converging. You know, what's a fintech now can be radically changed, can be a bank tomorrow, a hospital can be a fintech, a school can be a fintech, you know, because, you know, all these payment platforms and things like that are, you know, being democratized. There is also a lot of citizen data, you know, that's held up there across all these entities, in tax departments, in immigration departments, everywhere. So it makes perfect sense, you know, even for our intervention efforts to be converged at that level. And then maybe, lastly, is I think that we also need to keep track of those East Africa community initiatives happening. I know they've been working on this sort of, I think, data integration strategy program, you know, since 2023 or something, to the extent that we can help in facilitating, you know, those kinds of processes, even if it's just writing position papers and we put them on our websites. I found that a better intervention tool. Usually people will copy your work without even knowing. You'll be able to influence policy at that stage, you know. I've made some tweets that have ended up in parliamentary reports without me knowing. But once you're reading that report, you find, hey, this was, you know, something I read and just shared and opened like this. So I think for me, thank you so much, Amnesty International. We look forward to other collaborations. Bye.
Thank you, Francis. I think my last word would be, there was one of the panelists who say about awareness. I think we need to build awareness. We need to build awareness among our people to know that their data are very important. Their data is money, data is oil, as they say. But also I think there is also, as data privacy practitioner, we need to be concerned about corporate surveillance, and it's coming very fast. I mean, just give you one example. Here in Kigali, we have the government launched fintech sandboxes. So basically, all across the world, all fintech startup can come and test their product here. So you have a lot of direct marketing coming up on your phone. You don't know how those people get your details. You have all those Chinese companies, Alibaba and e-commerce giant operating here, and you have a lot of message coming through your phone or email, and you don't know how it comes, how those companies collect those information. And there is a critical need as we to have this conversation. I think I can emphasize on that. There is a critical, this is a very critical moment to have this conversation, and we need to have keep this conversation going forward to build awareness, because without awareness you can't even build capacity building of your people, because people don't know what's going on, what's at stake. And I think this policy conversation is very, very important. And thank you.
Thank you very much for that, Louis. Kachua, what is yours?
I think just to repeat what he said, especially about collaboration, I think it's very important that the society partners with, as he said, since it's a very niche area, with those who you would not think about. So many human rights organizations, so many human rights defenders, other civil society organizations, especially those working in governance, this would be very relevant for them. So lots of digital training, data protection training, supporting the data protection officers, that would be very relevant. Again, also awareness would also be, and advocacy, that would also be very critical, such that it's not just for specific groups, but to the general populace. And then lastly, I think that there needs to be not just the collaboration and the awareness, but even, how do I put it? As you come up with, there are emerging issues that come up, that there are new things that keep coming up daily with regard to data protection and human rights violations. So perhaps bringing out this research, having sort of symposiums, I would say, and then bring these different perspectives. So just something like this, but very tailored towards human rights would be a great step in the right, would be a first step in the right direction. Thank you.
Thanks. So my part should be that there's something Kisaka said earlier about the use of the words data is the new gold, data is the new oil. I view data as something completely different. And this is especially centering how Africa has been viewed time and again when it comes to resource. Because I think what people are trying to say is that data is a resource. But then I believe that as Africans, as the different societies within different African states, or the East African or beyond, we should be firm students of history. And when I say this, I mean, we actually currently no longer in the fourth industrial revolution, we're now on the fifth. I found that out recently. I was like, what do you mean? We're now on the fifth. I'm not joking, you can even Google it. And
what we're currently seeing, especially at the global level, is there's a bit of a hegemonic fight between the East and the West, and Africa is at the center, where there's a lot of Western companies, a lot of companies from the East that are actively extracting data from Africa. So I would stop saying that data is the new oil or the new gold. I'd call it that data is the new economic power. That would be how I view data. The second thing is, that means that as African states, we should be very keen on data sovereignty. And this is especially because different, like let's say the East African Digital Economy Strategy 2030 envisions an integrated identity system. An identity system that most likely will not be based, or like the data will not be stored in Africa because maybe we don't have the capacity for that. Or like not East Africa because we don't have the capacity for that. So that would mean that the first things we have to do is make sure that whatever regulatory, policy, funding, like streams we're trying to align with, have to eventually center data sovereignty. Otherwise, we're just giving out information, and the truth is, the same way technology, like let's say our phones and everything has always been built on the backs of Africans, whether it's through the extraction of resources, mining, whatnot, it will be the same. When all we are consistently as consumers, but never the producers. So that would be my parting shot.
My parting shot is go where you want it. We want to have collaborations with all of you in this room. Data Privacy and Governance Society of Kenya wants to collaborate with you, and we hope that you're also going to collaborate with us. We also want to partner and collaborate with our colleagues in Kigali, Kampala. We want to continue collaborating with our colleagues in Dar es Salaam and Zanzibar. So that is my parting shot. We want to collaborate with you. Let's make our partnerships work. Thank you.
Thank you very much for that. My parting shot is, thank you very much for your time. And I don't know if you have time for question or two.